Welcome back to this third segment of this law session on contract mistake. At the last segment, we did consider the mistake in one sense, and I told you that as soon as the break, we would look at mistake as to identity. Now, if we consider mistake to identity, there has been a flurry of activity in this area, and when it comes to a mistake as to identity, you should distinguish it from a mistake as to the capacity in which a party deals more than anything else, because when you look at mistake as to identity, there is this quality overlap with it as well, because you will see just how the cases have dealt with it. I mean, you can make your own decisions and see whether they are explicable. The first case I will start with is an 1863 case, Hardman and Booth, where the plaintiff there intending to sell cloth to Thomas Gandel Company negotiated with Edward Gandel at the firm's offices. Edward was an employee and he was not a member of the firm and intended to take possession of the goods for his own use. Having obtained possession, he sold them to the defendant, an innocent third party. It was held that the contract between the plaintiff and Edwards was void. The plaintiff had believed he was a representative of the firm and never intended to deal with him personally. Now, it is sometimes said that an additional requirement for the contract to be void is that the mistaken party must have taken reasonable steps to verify the identity of the other party. Now, it may be that this is more in the nature of an evidential burden to establish that the identity of the other party is crucial. Now, we have seen an extraordinary amount of activity, and there are various cases which sometimes are a little bit more difficult to reconcile, because it appears as if the court is trying to assist the parties, not least sometimes where you've seen the parties checked, and so the courts appear, in my view anyway, to be a little bit more sympathetic than they would in other cases. Now, mistakes as to identity, as I say, are generally induced by fraud, in that one of the parties is claiming to be someone they are not. There is therefore an overlap here, so there is also an overlap here also with misrepresentation. Now, a claim based in mistake is more favorable to one based in misrepresentation, as the effect of a finding of mistake is that the contract is void. Remember, with misrepresentation, you have to go through whether you're looking at a voidable situation there. This is important where, for example, you're looking at a situation where a rogue, the person who's misrepresented themselves, or the person who's come forward and saying they are the person you think they are not, for example. Now, it is important where a rogue has acquired goods and sold them on to a third party. That is one of the biggest discussions when you look at mistake in relation to identity. Now, if the contract is void, the rogue will never have received title to the goods and therefore will not be able to pass title when selling the goods. Now, there is a rule in contract law that you cannot give a better title than you have. So if I buy goods from a thief, for example, the person who owns the property can get the goods back from me because the thief did not have good title to sell it. Equally, if somebody has acquired good title, regardless of any dispute between you and them, that is between you and them. If they've had good title, then I can get good title. And again, I do say that if you're watching this and you come to do commercial law later on, these are concepts that you need to remember, because commercial law has a lot to do with title. It is just, as I say, a specialized type of contract law, but it is all about whether, let's say you sell, a big company, a retailer, for example, blouses to sell. If I go and I buy a blouse, if the retailer doesn't pay you as the manufacturer, it has nothing to do with me. You can't come to my house and take the blouse from me. That is because when you look at it, there are certain in-laws, certainly good title will have passed to me, because you would have been looking at something called a seller in possession. But that is outside the remit of this or the scope of this lecture, but I just needed you to have an understanding of it. If the contract is voidable, the contract exists and title passed, as we say. If the goods are sold before the innocent party rescinds, then the purchaser acquires good title to the goods. Now, in determining whether a contract will be held void for mistake, the court draws a distinction between contracts made inter absentis, meaning at a distance, and contracts made inter presentis, meaning face to face. Now, this distance face-to-face distinction has caused some problems, and I would certainly suggest that, again, as you read these cases, consider your own views on the cases, because examination questions really are about your views based on the reading of the cases. You're not going to say, I think or I believe. That's just a no-no. But you are going to submit then that based on X case and based on Y case, there is a strong argument that the principle is this, but notwithstanding the principle Z case, Z says this, and you need to be able to criticize Z case if you're holding fast to the belief that case X and Y were correct. That is what you need. That is how you need to read cases. Now, let's start with the inter absentis situation first. Well, where the parties are not physically present when the contract is made, example where the contract is made through dealings through the post, via telephone, or over the internet, for example, the courts will only make a finding of mistake if the claimant can demonstrate that there was an identifiable person or an identifiable business with whom they intended to deal with. Now, a mistake as to their attributes will not suffice. Now, let's assume that you go onto a website selling books, and the website calls itself Amazonia, and you think you're going on Amazon.com, for example, to buy a book. But you believe you're dealing with Amazon.com. You go through and you purchase something from this Amazonia, but all the time you think you're dealing with Amazon. That is what you thought you were dealing with Amazon. Now let's assume that similar scenario, you've got this Amazonia, but you're not bothered. You just want to buy the best book on contract law. So you go to this Amazonia website and you're buying a book because it's a book website. You didn't believe that it was the Amazon website. So in that regard, you are mistaken as to what the court calls its attributes. So there must be an identifiable person. For it to be sufficient to give rise to contractual liability, it must be that there was an identifiable person or entity or business, and that's who you thought it was. But you can't be mistaken as to the attributes. If you're just looking for a bookstore and you happen to come upon this Amazonia, it is neither here nor there. So a mistake as to attributes is not sufficient. Case Cundy and Lindsay in 1878. You had a rogue there, Blencarn. He hired a room at 37 Wood Street in Cheapside. This was in the same street that a very highly reputable firm called Blenkiron. His name was Blencarn. He went into the same street where Blenkiron and Son traded. Now the rogue ordered a quantity of handkerchiefs from the claimants, disguising the signature to appear as if it read Blenkiron. Now the goods were dispatched to Blenkiron, care of 37 Wood Street, but payment, of course, was not forthcoming. Blencarn sold a quantity of the handkerchiefs on to the defendant, who purchased them in good faith and then sold them on in the course of their trade. The claimants brought an action based in the tort of conversion to recover the value of the handkerchiefs. The success of the action depended upon the contract between Blencarn and the claimant being void for mistake. Now, if the contract was void, titling the goods would not pass to the rogue, so he would have no title to pass on to the defendants. Ownership of the goods would, of course, remain with the claimant. The court said that the contract was void for unilateral mistake, as the claimant was able to demonstrate an identifiable existing business with whom they intended to contract. Now consider Kings Norton Metal Company Limited and Edridge Merritt Limited, which is in 1897. In that case, a rogue ordered goods from the claimant using a printed letterhead and claiming to be a company called Hallam and Co. with offices in Belfast, Lisle and Ghent. In fact, no such company existed. The claimant sent out the goods on credit. The rogue sold the goods on to the defendants who purchased them in good faith. The rogue then disappeared without paying for the goods. The claimants brought an action for conversion of their goods based on their unilateral mistake as to identity. The court said that the contract was not void for mistake, as they could not identify an existing company called Hallam & Co. with whom they intended to contract. Now, the mistake was only as to the attributes of the company. So they mistakenly thought this company that said that they had 3 subsidiaries all over the place, that is not sufficient if you just thought it was a good company and it ended up being bad. It must be that there is an identifiable company for identity to work. Now, the contract, the court said, though, was voidable for misrepresentation, but that would not, if you remember, stop title passing. Because the idea here is the person you're bringing the action against, you're trying to get the goods back from them. But if that person can prove that good title passed to them, then of course you can't get it back. So the idea is to show that the rogue didn't get good title in order for you, the claimant, to get the goods back from the defendant. So as we said, it would not, framing it in misrep, even if it was, would not, of course, have stopped title passing to the rogue and the defendants. Therefore, he acquired good title to the goods. Now, we are going to take another short break, and we will return with the exciting case of Shogun Finance and Housen in 2003. And the question for you is, was Shogun Finance a missed opportunity? We will discuss that after this very short break.